Good morning, everyone. Good morning. How are you all doing? Let me put my phone number in here. Good morning. Come on in. Welcome. Happy Tuesday. If this is your first time joining, welcome. I'm just trying to put my phone number so I can pin it in here. Okay, there we go. Good morning, everyone. Welcome. Bonjour, Musa Odrego. Good morning, Muhammad. Good morning, Facebook, YouTube, Instagram. Welcome. If you're tuning in for the first time, my name is Aisha Chidole. I'm an immigration attorney out in Atlanta, Florida, but I represent clients in all 50 United States. We handle family immigration, humanitarian-based cases, consular processing, removal cases. If you'd like to schedule a consult, call us 678-325-1037 or 678-233-2170. Okay, so today I kind of had a list of questions I went over, or I had one of my staff get for me, like some of the lives that I was not able to answer, over the last, just to kind of talk about them, and so I just kind of want to dive into some of those questions because, if one person's asking, that means that other people are asking. So one of the questions asked was, can you become a U.S. citizen if you're arrested but never convicted? The answer to this is a very lawyerly answer, which is that it depends. It depends on what the arrest was, what was the outcome of the arrest, and also the timeline of the arrest. When we are looking at citizenship, the crimes that are really considered to make a determination if someone should become a U.S. citizen are what we call crime of moral turpitude. So think about things like, felonies, aggravated felonies, anything related to drugs, anything related to violence, multiple DUIs, and, and things like that. So conviction is very state specific, where sometimes they might defer conviction in lieu of some sort of punishment or something like that. So the answer really depends on what the crime is, what exactly you were not convicted of, or whether it was just dismissed. There was literally no case to bring forth, or that you were found not guilty, and also timeline. Because when you are applying for citizenship, while they are looking for 5 years of good moral character, they also have the flexibility to go as far back as they want if they are looking to see if you are a habitual, offender or violator of the law, or that, you basically do not follow the law and you're not going to be a law-abiding citizen. So that's what they look at. Okay. Let's see. So the other question I got was, I received a NOID is a notice of intent to deny on my I-751. What should I do? So the first thing is, what is a notice of intent to deny? A notice of intent to deny basically means that USCIS has everything that they need to see. And based on everything they need to see and your history, that they plan to deny your case, unless you can prove otherwise. With a notice of intent to deny, you're usually given somewhere between 30 to 33 days to respond, depending on if it's via mail or if it's being, downloaded or whatever. So with the NOID, a NOID is something that you take very, very seriously, because if you have an I-751 and you cannot overcome all the challenges that USCIS has challenged you with on your NOID, it means that your case will be denied. And when your I-751 is denied, your green card is terminated. Your green card status, your status as a conditional resident is terminated, and you are then placed in removal proceedings. So you always first of all, if you have annoyed, you should be contacting a lawyer. That's number one. Like, I mean, it should go without saying. You need to contact a lawyer. You know, I can't tell you how many times people come to us after the fact, after the denial, and you see the annoyed response and you realize they didn't even address what USCIS was asking them to address. Meaning, if they list 10 things, you cannot omit one. You have to address every single one of the issues, and you have to present supporting evidence or a compelling explanation of whatever it is to overcome it. You know, can annoyed be overcome? Yes, annoyed can be overcome. If you have supporting evidence to overcome it, I mean, I'm sure there are people who we've represented on their annoyance here that can probably testify to that. But are there other times where someone's case is so jacked up, you know, for lack of a better word, meaning they have like basically destroyed their immigration path based on, you know, lies or maybe things they did in their B1, B2, or things that happened like in a home visit, or things that they said that there's literally no way around it, and they have no explanation to overcome what it is that USCIS has observed. You know, I told you guys yesterday for I-751s, those of you who are filing I-751s and you're doing a joint filing, you know, you should expect a home visit. If you don't have a home visit, great. But they are definitely, but you should have a mental preparation that on any given day, USCIS can choose to visit your house, because that's what they're doing. Right now, you know, if you're saying that you have a good faith marriage, you know, in I-751, they should find that you guys are in marital union. So, you know, so yes, you can overcome it, but it is something that you first of all need to understand what the issues are, what it is that they're looking for, and then going through to see how you can respond to that and how you can basically overcome that annoyed. All right. Okay, so let me see what other questions here before I go to my other list. Lucha says, thank you so much, Ms. Aisha. You've proven yourself over and over again. Much appreciated. Thanks, I appreciate that. Cheryl says you have a question. If you have a question, you can just type in your question. If it's something personal to you, you can always just schedule a consultation or comment yes, and someone will reach out to you after the live. You can comment yes on my Instagram live. I don't think it works on the Facebook, and someone can reach out to you afterwards. Okay, so the other question I got, which is a really good question, is can you miss your green card interview and still save your case? This is a really good question. So yeah, it's possible, but it's really going to depend on the reason why. So whenever you can give notice prior to missing your interview, it's always important to give notice. We've had varied reasons why people miss interviews. It depends on what the interview is. If it's a marriage-based interview, and obviously you're a victim of abuse, and all of a sudden your spouse is saying you don't want to come, in that case, there's no point of missing the interview. If you've already been scheduled, you attend the interview with your abeyance letter, you know, basically requesting 30 days to allow you to file, you know, an abuse petition because your spouse has been abusive. Now, USCIS doesn't necessarily have to approve that, but generally I would say 60% of the time they will approve an abeyance request. You just need to have that file received and receipted, unfortunately, within the 30 days. That's the unfortunate part, because, you know, we know that, you know, filing receipts can take a long time, but if USCIS can go in and see the received date, sometimes they will then keep the case open. If the case does get denied and you are still eligible for an I-485, you know, you should still file the I-485, meaning if your 485 is denied because you don't have that receipt, you can still, once you get the receipt, you can still file a new I-485. Another reason why people might miss, you know, an I-485 interview is because they're sick. You know, if you're sick, you know, you want to reach out to USCIS customer service and let them know the situation, or have your attorney reach out to them to let them know the situation so that you can be rescheduled. Other times, you know, you are in the wrong location. We're seeing a lot of this one, by the way, actually, where With a lot of these new processing centers they've opened, we're seeing a lot of errors coming from USCIS's scheduling unit, meaning like they're scheduling people for locations where they don't live, and when the person doesn't show up, they deny the case, even though they've received so many letters or phone calls with service numbers basically saying, this person doesn't live here. This person has never lived here. You scheduled them for biometrics in Utah. Why would you now schedule them for an interview in Atlanta? I'm using that as an example. And when that happens, of course, we have to either file an appeal or do what we call a sua sponte motion. For us here, we always first try a sua sponte motion. The problem is that appeals has a very short window. Like, you have 30 to 33 days. So a sua sponte motion is basically where we reach out directly to the field office director of the location that the client or person was denied, saying, this person doesn't live here. Here's evidence that this person doesn't live here. Here's evidence that USCIS was contacted to change the interview location. Here's evidence that you do know where this person lives because you scheduled them for biometrics in the right place. So please reopen the case. So that's another way that they can reopen your case. So it sucks having to go through that process, but that's the thing that happens when you have just a mass amount of new staff. Part of that growth is that many people are not necessarily trained, or even sometimes what we've seen recently with cases like with I-751s where, they've changed kind of like processing centers where you can select more than one category if you qualify under an I-751, for example. Like if you're doing like a waiver, you can select more than one categories. We've seen where USCIS would return, like whoever is in the filing or processing room will return it and say you didn't select a basis for the waiver, and you literally have to send it back with a printout of the law, like on top, and say, hello, here's the law highlighted. So this happens. And so, of course, it is frustrating for the clients, but it also is frustrating for us as attorneys, because for us as attorneys, when USCIS makes a mistake, when USCIS passes laws, it is us who have to be the pain and the anger absorber, from the clients. Why did they send my packet back? Why did they do this? Even though it has nothing to do with us, and we followed the right way. So you can still preserve your green card or appeal it, or have them do the right thing and reschedule you for the correct location. Because what sucks is you end up buying a ticket and traveling to the wrong location, and then you get there and then they tell you, well, we can't even interview you because we don't have jurisdiction to interview you. So yeah. Okay, so let me see what other questions. It's been 4 months since I submitted my RFE, nothing yet. What's next? I filed for VAWA in 2022. I don't know. My service keeps going out. My service keeps going out on Instagram. I don't know why it keeps pausing. It's driving me crazy. But hopefully you guys can hear me on Instagram. There are no timelines for RFEs. People ask me that all the time. There are no timeline for RFEs. Whether an RFE will still go based on what the normal processing time is. For VAWA cases, they are still processing 2022 cases. In fact, we have a 2021 case. Her interview is tomorrow, and I'm wishing her well, where she actually has a VAWA interview, because you do know now that some people are interviewed for I-360s. I say that to say you're still in a normal processing time. 4 months is not a long time to have submitted your RFE. There's just a delay, with VAWA cases right now. Because I talk about this all the time, so it's actually a bit exhausting talking about it all the time. Because they are doing interviews for I-360s, these cases are just taking a longer time because of the vetting and everything else that they're doing. In the past, they could make a decision on the I-360 without an interview, and then they will schedule you for an I-485 interview, or bypass you for an I-485 interview. Now, all I-485s, you will be scheduled for an interview. Like, we actually had one client that wasn't, but this was earlier last year. All have been scheduled now, you know. So you will be scheduled for that. But also, a lot of people also will have I-360 interviews, and so that causes delay. I can't tell you why, what the process is with the delay, but I've told you guys before that when you look at other cases or other case types, not VAWA cases, T cases, and U cases, for instance, those cases are processed by so many different field offices across the country, right? So, like, if you're in Florida and you file for a marriage-based green card, who's processing your case? Your location in Florida. So if you're in Jacksonville, you got Jacksonville processing your case. If you're in Orlando, you got Orlando processing your case. If you're in Tampa, you got Tampa processing your case. So you have like several different field offices processing cases from Florida. But take VAWA, for instance. There has been an unprecedented amount of people filing for VAWA based on IE1, either knowledge that they didn't know this was something that was viable to them, and now they know, and two, because there has been an increase in fraudulent cases. But you also have only one unit processing those cases, meaning those cases are being processed in Vermont, or those cases are being sent to a field office for them to be interviewed for VAWA and then being resent back to Vermont to process. So imagine you have 30 locations processing a marriage-based case in one state, whereas you have one location processing 50 states of the same type. By default, there will be a delay, and something I always say to people, even though there is a delay, and I understand the frustration not knowing and not having your green card and still just feeling stagnated, if you have the ability to get a work permit and get your Social Security because you're eligible for adjustment of status when you file your VAWA application, you should definitely do that and make sure that you are renewing early, like renewing your work permit early. So at least you have that while your case is pending and you can continue to renew that. Because it's just going to be what it's going to be. So unless they create new centers that are going to actually process them, I fully expect delays. It's the same thing with T cases where they're being processed from the same place. These take a long time. Same thing with U visas. So that's the reason why. So whenever you guys ask me, what are they processing? What are they processing? The answer still remains the same unless I tell you otherwise. Okay. I filed for my dad and my 2 kids on the same day. My dad's case is the only one moving forward. My dad got an interview and medical, only to be told there's a pause. You said ban, but I'm going to correct you and say pause on the 75 countries, because I'm assuming that your dad is from one of the paused countries, because a pause is not the same thing as a ban. So yes. There are pauses. There are lawsuits that we're waiting for the outcome of the lawsuits on those pauses, because these are just kind of like an overbroad blanket of pause without any notice as to when they're ending. And this is for if you're outside of the United States. So typically you'll get to that point and they will tell you that. I am assuming, or they should have probably told your dad that, contact us at whatever address once the pause has been lifted, just so that we can finish processing your case. So that is what is happening if you're outside the country and you're either from the 35, the 30, see, I can't even keep track anymore, the 39 banned countries versus the 75 paused countries. So they will process you up until the interview. And if the only thing that is stopping them from approving you is the ban, it is hopeful that once the ban is lifted, that'll be the only thing. If there is something else that is stopping you, they will tell you right then that we're not approving you because of this, and in addition to that, this. And those are things that you can either take care of if you're able to take care of them, or not. If you are, or if you do have, if it is a fiancé visa that you're filing, and you are from the pause country, they are still processing that. If it's a fiancé visa that you're filing and you are from the partially banned countries, they are still processing those fiancé visas, and those applicants are still able to come to the United States, and get married to their spouses and file here. And as a reminder, the pause has been lifted here in the United States. So I want to make sure that you guys know that. We've been just kind of rounding up the results that we get, especially from those countries, and posting them on either on Thursday or Fridays. Last week, I think we posted it on Thursday because we had the public holiday. So on Friday, you would see. So we've definitely seen some movement in some, a lot of these countries. Obviously, I post the countries that, we're getting that are my clients. We do have a lot of Nigerian clients, and I know there are a lot of Nigerian clients on this that come on live that ask. So that's why when we post, we try to include those flags so you can find yours and see, what is applicable to, your country. Okay. My brother filed for an I-130 in April of 2025 via a lawyer, and we haven't heard anything yet. The ages are 15 and 12. Is there anything he should be doing? The question would be, what is your brother's status? Is he a green card holder or a U.S. citizen? So the answer will depend on that. But let me just make the assumption that he's a U.S. citizen just for conversation's sake. If your brother is a U.S. citizen and those children are outside of the United States, this is one of those times where, honestly, having this delay is actually welcome. I don't know if you heard me just about 3 minutes ago where someone just said the father went to the interview and the person was told that there's a ban or a pause. I can't remember now what she said. And so they couldn't make a decision. But that buys you some time to go through the consular process and to allow them to lift the ban. The pause will be lifted. Same thing with the ban. It will be lifted. The ban, I don't know when, but this pause will be lifted sooner rather than later, in as far as my opinion and assessment. Just the same way that the pause has been lifted here in the United States. It's just a matter of time. Now, and I'm also making the assumption that the reason why you ask is maybe you are from a ban or a pause country. I don't know if you are from one, but if that's the case, why rush the process if you know that they will get to the interview stage and they'll say because of the pause of the ban, they can't. So instead, let them follow the normal process. Their ages are locked in at 15 and 12, from a CSPA, like from a child age protection standpoint. And then once that's approved, let's say at some point this year, because they probably will approve it at some point this year, because it's only been pending for about a year, which is really not a long time. And then when he gets to NVC, go through that process. And after you go through that process, then move on to consular processing, right? And scheduling the interview. So this is one of those areas where, it's within normal time, but why rush the time if there's not going to be an outcome right now until they lift that? Does that make sense? So someone just said, I got a notification via Case Tracker app stating that I missed my interview, but I haven't received any physical correspondence. What should be my next step? So I literally just talked about it. This was one of the questions somebody else asked me, once I had begun this live. The first thing you need to do is you need to contact USCIS like today. Like as you get off the phone, you contact them and tell them that you didn't receive an interview notice and this is the notification you got. You also go online and you go to Ask Emma and go into your and select, did not get notification. There's an option that says did not receive document or receive notification, whatever it is. complete that all, get a service number just so that you have that if you need to appeal. So do that immediately, ASAP, right away. And then if you have USPS informed delivery, I talk about this all the time, and I'm about to jump off live, but I want to just talk about this for a second. Everyone, immigrant or not, you should have USPS informed delivery. What is USPS informed delivery? USPS informed delivery is that every time a mail comes to you or is coming to your household, you get an email. And the reason why you do that is when something like this happens and they claim that they sent it to you, you can prove that you never received that mail. We had a client that was denied for the exact same reason on her I-751, and we went through the entire month of when they said they quote unquote mailed it. And we screenshot and posted every single email from USPS informed delivery, showing that she never got that mail. And that case was reopened, and then they just skipped the interview and granted her 10-year green card. So, it is something that's beneficial, especially if you expect to mail. It is also something that is beneficial if you are trying to prove good faith marriage or cohabitation. So it's not just for interviews, but it's also when USCIS is asking for documents to prove that you lived in that household, because it sends you photographs of mails that you have incoming, so that way you can save that. You can save that and show, well, look, if I didn't live in this household, why do I get mail here every day? So that's just a free gem I'm giving you guys. But I got to jump off. But I hope you guys have a great day. I'll try to answer more questions tomorrow. Again, schedule a consultation if you want to talk about your own specific case, how we can assist you, how we can see if you have any options. Our number is 678-325-1037, or you can also text us on 404-333-8751. That's our WhatsApp number. If you want to book a consult, also, you can do it directly through our website, which is chidolelaw.com/booking. All right, guys, I hope you have a wonderful rest of your day, and I will talk to you guys later. Bye.